Hello, my name is Deborah Fosbrook. I'm co-author of Contract and Copyright Drafting Skills, published by Bloomsbury Professional. What I'm going to talk to you about today is Force Majeure. You may or may not be aware of what that actually is, or actually even seen a Force Majeure in a contract. It's a very common clause, but it's often one that's left at the bottom of a contract and quite often ignored. What does Force Majeure mean? Force Majeure is a clause which is relied upon by one or more parties to an agreement, depending on whose benefit it's drafted for, in order to avoid liability under an agreement. So it's where there's been a breach of the agreement and the other party comes to you and they says, we're relying on Force Majeure because it is an unforeseen circumstance which has arisen beyond our reasonable control and that we couldn't have expected to have foreseen. So that's what the scope of Force Majeure means. Is it right that there should only be one Force Majeure clause that applies to all the parties? My opinion is personally that it shouldn't, that you must draft Force Majeure clauses specifically for the benefit of yourself under each and every single contract that you do. The reason for this is because what you're trying to do with the Force Majeure clause is to limit liability, limit risk, limit cost, protect your company or protect yourself as an individual, so that if a circumstance arises at a later date, you can rely on that clause and say, this is what's happened, it's not necessarily a breach of the agreement, and other situations can occur as a result of that. So what sort of areas are usually covered as issues within a Force Majeure clause? Well, the standard ones are war, epidemic, hurricanes, volcanoes, chemical warfare, nuclear warfare, all sorts of situations which relate to man-made incidents or unexpected acts of God, which basically could not be foreseen. So, and the consequences is that they would be beyond someone's or company's or a person's reasonable control. Now, there's a lot of grey areas. Does that mean that a civil uprising falls within Force Majeure? Does that mean that a lack of electricity or gas or lack of a supplier to provide products to you falls within Force Majeure? Well, the answer is that you have to either include these issues or exclude them under the Force Majeure clause. Quite often people don't. So when I'm drafting a Force Majeure clause, I'm specifically saying I want a very wide clause, so I'm throwing in as many issues as possible to make the Force Majeure as wide as possible, so if at a later date there's an electricity failure, power failure, there's a transport strike, I can then rely on that clause not to be in breach of the main agreement. The opposite side of that is to exclude as many issues as possible. So you would exclude, for instance, the fact that a factory is closed down, a factory's got a strike, there's a blockage at a port. So you can play with the clause. A lot of people don't, they just bucket list issues in it and don't really see that you're excluding and including liability. The other part of this clause is that basically you've got to have a process for relying on the clause. So what you want to set out within the clause is almost a second part. Once you've dealt with what's in the clause, what's in Force Majeure, what's included, what's excluded, is, well, what elements of the contract does that actually cover? So you may, for instance, say you cannot rely on a Force Majeure clause in relation to X, Y and Z clauses. You cannot exclude liability for personal injury and death in most countries in the world. So that's not something that you should try and do. What you may try and do is consider the option of taking out insurance cover and taking out policies for unexpected situations. But the process of making a claim, say for instance I'm party A and the other party B wants to make a claim relying on the Force Majeure clause, it should have within the clause a requirement that they write to you as soon as possible, notify you as soon as possible. You know, you can specify the method by which they contact you, who they contact, that they should set out in detail the problem which they're relying upon to make the claim of force majeure, and also the time scale in terms of what their expectations are as to how long that situation may arise. So that's the process of notifying in terms of, you know, we don't believe we're in breach of the contract because we're relying on force majeure. The other part is that you may draft a force majeure clause so that immediately that they notify you on relying on, the other party notifies you that they're relying on force majeure, that you have the right to notify them that you are terminating the contract, because this is something you should have discussed and negotiated up in advance. You may not be able to wait for 6 months while they're unable to fulfil the terms of the contract. You may not be in a position as a business to have that period where the contract is suspended or where the contract is not being fulfilled. So you can have different alternatives in terms of the consequences of what the next step is. The next issue is if the contract is terminated or if there is a period of suspension of the contract, is what liabilities arise from that, what costs are incurred, what expenses, what actions will either of the party have to take which will incur financial consequences, and who will be responsible for those costs and expenses. And that's a very, very important issue. It's not academic, it's not you know, that you could have with very large contracts very considerable consequences for one party being able to fulfill the terms of the contract because there's a war in a country from which they were getting materials or from which the data was coming. So that's a fact that you need to consider. There's the other issue is either after termination or during the period of suspension, who owns the material which is in existence? In the meantime, you know, would you have the right to go to another third party and get that third party to fulfill some of the terms while that contract is suspended? So it's about being, you know, looking at the bigger picture and then including very practical elements, which means that when you're faced with the situation of somebody coming to you relying on a force majeure clause, or you relying on a force majeure clause, that actually there's a process in place that allows people to resolve the issues going forward rather than immediately enter into litigation.